Assalamualaikum warahmatullahi wabarakatuh to our respective lecturer, Madam Asnalisa Arma Asnan. I'm Nadira Maisara binti Zawri, metric number DIA201013, and my group partner Nur Atika Frizana binti Rashidi, metric number DIL211002, will present about a case law that have been given from our lecturer.
Induk Sundaram Berhad is a company which deals in the sale and repair for personal computers. The directors are Sanjay and Sangeeta, who holds 30% of the company's issued shares, while Chong and Rani are the shareholders and each of them holds 20% of the issued shares. The company made a profit of 10 million last year. Chong and Rani have discovered that Sanjay and Sangeeta have been misusing the fund of the company for the entertainment expenses purposely on behalf of the company.
Firstly, in our opinion as a legal advisor, the shareholders have their rights to remove both of the directors, as both of them has breached the fiduciary duties to the company as they are misusing the funds of the company for entertainment expenses on behalf of the company. This shows that the directors have violated the fiduciary duties to the company as they did not use their powers in a good faith.
The issue in this case was whether the directors had breached any fiduciary duty to the company. Company Act, Section 213, Duties and Responsibilities of Directors. A director of a company shall at all times exercise his powers in accordance with this Act for a proper purpose and in a good faith in the best interest of the company. Re W and M Roth Ltd, 1967, 1 WLR 432. A director, Mr. Roth, entered into a service contract with his company providing for pension to be given to his wife in the event of his death without taking into consideration as to whether the contract was for the benefit of the company. The object of the contract was considered not to be binding on the company as it did not benefit the company by Mrs. Roth.
Next, referring to a Company Act Section 218, prohibition against improper use of property possession. For example, a director or officer of a company should not, without the consent or ratification of a general meeting, and use the property of the company. For example, the case law referring to Section 218 is Cook vs. Days. This duty is so strict, it applies even when the company, by some reason, is incapable of performing the contract. For example, where the offerer dislikes most of the boards but likes one of the directors and offers the contract personally to him, as in the case of Industrial Development Consultant LTD vs. Cooley. Furthermore, referring to a Section 206, removal of a director may be removed before the expiration of the director's period or office as follows, subject to the Constitution in the case of a private company by ordinary resolution. For example, a case of Section 206 is Racemead and Fawcett. Newly appointed director refused to register Fawcett share in the name of executor unless he was willing to sell half of them to Smiths. The company article states that directors may at any time and in their absolute and uncontrolled discretion refuse to register any transfer of shares.
Sanjay and Sangeeta, the company's director, were found squandering the company's fund. According to Chong and Rani, who is the shareholders, the directors was wrongdoing by using the company's asset. For example, the directors spent 1.5 million ringgit on Rolls-Royce for entertainment costs that were purchasing on behalf of the company. The company also has paid Raja, Sangeeta's sister, 3 million ringgit to purchase a plot of land from her. Moreover, a donation of 2 million ringgit was made to the Blissful Old Folks Home. Logically, the company does not gain anything from it because the two directors are only doing it for fun. Because of that, the company does not make any money from it. And as a result of the directors' reckless behavior, the company had to endure a substantial loss as a result of their financial misappropriation based on Section 218, Prohibition Against Improper Use of Property, Position, and etc. A director or officer of a company shall not, without the consent or ratification of a general meeting, Clause A, use the property of the company.
So another application is the shareholders have their rights to remove both of the directors as both of them has misused the company's fund for entertainment expenses purportedly on behalf of the company. A director owes a fiduciary duty to a company to prevent its assets from being deployed illicitly. The director should not misuse his position to obtain benefit or advantage for themselves except with the consent or general meeting. Based on Section 213, Duties and Responsibilities of a Director. Last on application is, a shareholders have the power that is unfettered and may be used for a number of purposes, including removing directors who are misusing company funds, based on a Section 206 removal of a directors.
In conclusion, the directors had breached the fiduciary duty which the directors don't exercise the power for proper purpose, and they did not avoid conflict of interest. The directors also did not use their power in a good faith, as they misusing the company's fund for entertainment expenses. The shareholders have their rights to remove the irresponsible directors from the company.